Welcome to Frank Bruno Law. I am Frank Bruno. I'm an estate planning and elder law attorney located in New York City. Today I'd like to start a multi-part series on trusts. What is a trust? But first, if you'd like to set an appointment with me, if you'd like to speak on the phone, please go to callfrankbruno.com. What is a trust? Well, I'd like to give you some information about this area of the law. I will tell you that it's a very broad and deep area of law. It's an area that I've studied for years. I've gone to many trainings, week-long training sessions at a time, and I've practiced in this field for a long time. So we can't get everything at once, and we're going to take small little bites, and together we'll explain a little bit about trusts and have you learn a little bit more so that you can make a sound decision about your own situation. Well, what is a trust? The legal terms for a trust is it's a contract. It's a contract between the grantor, the trustee, and the beneficiaries. A grantor is the person that owns the asset. The trustee is the person that controls the trust. In certain trusts, it could be the same person. And then the beneficiaries. Those are the people that receive benefits from the trusts. Okay? Now, there are two broad categories of trusts. One is called a testamentary trust, and another set of trusts are called living trusts. And we can describe those by thinking about a testamentary trust is created upon your death, and a living trust is created while you're living. A testamentary trust is created within your will. And I want you to think about it like this. We call the title of the document, right, a will. It's a last will and testament. So within that document, upon a person's death, there can be created a testamentary trust. Now, that trust has no effect during the life of the person. It is created upon the person's death and after an executor goes to surrogate's court and has the will probated. So the situation with a testamentary trust is that it's not a useful document for disability, and it's not a useful document to avoid probate because it requires probate to exist. So that's a testamentary trust. There's more things I could say. It's more detailed and complicated than that. But as an initial discussion, that's when we're going to leave testamentary trusts. The other very broad category are living trusts. As the name implies, although it's not always intuitive, it's created while you're alive. While you're living, you create either a revocable or an irrevocable trust. Revocable means revocable. Revocable means you could rip up the trust. You could revoke it whenever you wanted to, if you wanted to. There are consequences to that, circumstances, but broadly, that's what revocable means. And there's an irrevocable trust. That means once you put any assets into the trust, they can't get back out of the trust without some difficulty, right? There might be a way that we could explode the trust or break it up or ultimately end it. But really, very concretely, revocable can be revoked. Irrevocable cannot be revoked unless certain circumstances exist. If you have any further questions about this or any other related topic, elder law, estate planning, please go to callfrankbruno.com. You could also look at my website, frankbrunolaw.com. I'm open for questions, comments, phone interviews, and in-person meetings. So thank you very much for your time. And this is just the first of a multi-part series on trusts. Thank you.